Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
I'm Marnie. I'm one of the lawyers at SpringLaw, and I'm here today with Tiffany Thomas, one of my colleagues who's also a lawyer. And we're going to talk to you today about best practices for employee exits and a swift sign-off on termination letters and severance packages. If you're one of our clients, you already know that we're an employment, labor, and contracts firm. And if you're new to our firm or to our webinars, welcome. We're happy to have you. We have got a really big attendee list, and we're excited to talk to you about this important topic that many of you deal with on a daily basis. No, not daily, hopefully, but regular basis. We're a fully virtual firm based in Ontario. SpringLaw does a webinar every third Wednesday of the month, and we cover different legal topics in each webinar. We try to tailor our webinars and blog content to the issues that are coming in the door for us from our clients, employer clients, and employee clients. Feel free to ask any questions you have using the chat function. Our team will send us the question, and we will take questions at the end of the webinar and try to get to as many as we can. There are slides in the handout tab if you want to grab those and follow along with us. And if you have any questions generally about our firm and you want to learn more about us, feel free to visit springlaw.ca. You'll find our award-winning blog, again, written based on the issues we see our clients dealing with. We have a monthly newsletter and subscription programs as well. There's information about those services and bundles that we provide for on a flat fee basis. So head over to our website and check out all of those offerings. Few other housekeeping matters. Tiffany is going to drive the slides. We're going to start with a land acknowledgement. Acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and Wendat peoples, and that this territory is now home to many diverse First Nations, Inuit, and Métis peoples. We have a dense legal disclaimer on our next slide, and you can read that at your leisure. But the main point is that we're providing legal information today, not legal advice. And our goal, as is the goal with every webinar, is to equip you with enough information to issue spot and decide whether this is something you've experienced dealing with and can handle on your own, or when you might want to seek out and get legal advice to reduce risk of increased costs or legal claims and so on. So we hope by the end of this webinar you'll be well equipped to issue spot relating to terminations and exiting employees. Next slide, please. All right, so our presentation roadmap, we're going to start with some early considerations when you've made the decision that it's necessary to exit one of your employees, and we're going to talk about employment contracts and other relevant factors that you need to gather at that front end. The whole presentation is designed to be handle the life cycle of an exit of an employee to the final sign-off or the final dealings with the employee, and hopefully by that point, both the employee and employer are in a better place and on to their dealing with this termination situation in their rear view and dealing with a positive move forward. So that's the goal here with this swift termination and swift sign off to equip you with tools to get to that point. We're going to look in detail at the employment contract and give you some tips to figure out whether or not there is an issue with it and what you do if there is an issue or potential issue. And we're going to talk about tidy without cause terminations. As you'll see, that's the focus of our webinar because those are the most common issues, termination related issues that we deal with. Tiffany's going to talk about challenging employees and a practical approach to where there may be cause for termination and how to handle that. We'll talk about termination packages, run through the basic legal obligations, and then give you some ideas around practical structuring, again, all with a view to a smooth exit and a quick sign-off. We will talk about responding to the demand letter that lands in your inbox, never a fun day, and some initial considerations and ideally how you're going to handle that with your employment law counsel. And then we'll finish off with, we're weaving best practices throughout the whole webinar, but we'll finish off with a few more for directly designed for that quick sign off. And then Tiffany's going to run through some takeaways for you. So hopefully a really practical webinar ahead of us to help you deal with what is probably one of the least fun things to deal with for any of you who are wearing an HR hat. And we reviewed the attendee list before joining today, and I see that there are a lot of folks from Ontario and some from across Canada. Our advice or our information applies generally to all employment situations and workplaces. We will flag when we're talking about Ontario, but overall, these are practical considerations that will apply throughout Canada. And our advice also is designed for HR professionals or anyone wearing that HR hat or a general counsel, individuals in a role where they're making internal decisions and deciding whether or not the legal spend for external counsel is worthwhile or not. So that's hopefully we're going to equip you all to deal with your preparing for a termination and the various stages that happen throughout that process. Moving on to the next slide, please. Okay, so the early considerations. When you are deciding, when an employer is deciding or has decided it's time to exit an employee, the first thing you're going to do is dig up the contracts and any plan documents, so bonus plans or incentive compensation documents applicable to that employee. This might also include the employee manual, although those tend to be more generic, the policies and employee manual. You have to decide on case-by-case basis there whether the policies apply to your particular employee, but generally it's the employment contract, or also known as the offer letter, whatever it is that the employee signed, and applicable plan documents. Gather those. Hopefully you have signed versions of them. If you only have unsigned versions, that may come into play, and that's something they should flag for your legal counsel. Which documents actually apply to the employee is important. Whether if you've given a promotion to the employee throughout their employment, you have to figure out which one's enforceable and whether they were provided with consideration, or otherwise known as something of value, in exchange for signing that document. So you do an analysis of which documents actually apply. Sometimes we have employers send us 3 or 4 versions from a 10-year employment period, and there's an analysis required to figure out which one we are advising on. Then in the applicable documents, you're going to identify the termination related provisions. And sometimes we talk about the termination provision, but we're speaking more broadly about all termination related language is what's important here. And Tiffany's going to get into more detail about what that means. But you want to identify that language, and that's what we're going to follow and figure out what the employee is entitled to on termination. And Tiffany's also going to talk in detail about the Waxdale case and why this is one area where it's worth the legal spend, even at a higher level, to determine where you stand with your termination-related provisions. I've been practicing employment law, specializing in employment law for almost 20 years, and I would say that this is this recent case law is probably the biggest change I've seen that has a regular impact on employment relationships, and we're doing a lot of work to help employers clean up their termination provisions, and it has a big impact on how we advise in termination situations. We do like the DIY approach at SpringLaw wherever we can, and I don't like paying lawyers, and I'm sure you don't either, and your employer doesn't either. And we do try to help with the DIY approach and have you not need us. But this is an area where I would typically recommend it's better to check in with employment law counsel before you forge ahead. All right, next slide, please. All right, so I've talked about the contract. There are a few other things that you want to look at these early stages. And when I work with my employer clients, the ones I've worked with for a while, will know that the kind of information they should send me for a quick eyeball of, okay, what are we dealing with here? And do we need to have a conversation? Or they're just checking in with me and saying, this is what I'm thinking. This is the package I would like to go ahead with. What do you think? And they know what information to send to me. If I'm working with someone who's new to SpringLaw, we have termination worksheets and forms that ask the appropriate questions so that we can get that information quickly and do a high-level review and decide whether there's a further conversation or meeting required. So some of the things that fall into these early considerations are whether the employee was induced to join the employer, and that can impact the severance package, whether they relocated for the role, and whether they were promoted throughout their employment. I've already talked about that, because the documents, the applicable documents, can change based on what's happened during the employment relationship. And just generally, what you want to do when you're gathering all your documents is prepare a chronology or detailed employment history for yourself and for your meeting with your leadership team. If you're going to be the ones deciding on what the severance package is and you feel that it's a straightforward matter and you can handle it, or for your legal counsel, putting that all together is going to make the whole process more efficient and save on legal fees. So all of those steps, that homework that I've gone through, gathering the documents and preparing a summary, or an employee bio, I sometimes call it, sets the stage for a tidier termination process and a cheaper termination process typically.
Thanks, Marnie, for all that super helpful information. Good morning, everyone. As Marnie said, my name is Tiffany. I'm another lawyer here at SpringLaw. First and foremost, along with our tech issues, our cameras were acting up this morning, so if you happen to be viewing me in extra zoomed-in version, I do apologize for that, but the legal advice and information will remain the same in any event, no matter how zoomed in I am. So let's turn to this seismic shift that Marnie referenced a few minutes ago. So in June 2020, the Court of Appeal released a decision that employment lawyers typically refer to as Waxdale. This was a wrongful dismissal action following a without cause termination. So why was this such a seismic shift? Well, it was such a seismic shift in Ontario employment law because essentially for the first time, the highest court in our province concluded that the termination provisions in a contract must be read and interpreted as a whole, and that courts will not enforce termination provisions that are even in part illegal. So in practice, what this really means is that if you're terminating, let's say, without cause, but your with cause portion of your termination provision is unenforceable, your entire termination clause is now treated as unenforceable. So bottom line, if you're terminating, whether with or without cause, and even a part of your termination provision is found to be illegal, a court will not uphold the clause or its application to your recently terminated employee. There were some, or maybe still are some, attempts to sort of get around this, or some thought process that maybe having them in separate places of the contract would work. That's not going to work. Whether the two termination provisions or however you structure your contract, if they're in separate places of the contract, lawyers, courts, they're going to look at that. You can really expect that following the termination, if your employee hires counsel, that counsel is going to scrutinize the entire contract. They're going to look at certain places with a really fine-tooth comb, but they're going to look at the whole thing. And if you have termination provisions inadvertently hiding in other areas of your contract, you want to be really careful. We're also starting to see what I would say is a bit of a creep. So we're seeing that the courts are starting to look at other standard areas of your employment law contracts and determining, is this enforceable? Does this create a problem for the termination provision? So what I would say here is the key takeaway is, with this huge seismic shift and with this increasing creep, is a really good time to think about auditing your contracts and determining whether they really are enforceable. And I failed to change the slide, so sorry about that. I'll pass it back over to Marnie.
Okay, so what Tiffany's talking about, she talked about the Waxdale decision. So I refer to when there are issues or potential issues with a termination clause or termination related clauses, we like to refer to that as a Waxdale problem. So if you don't have a Waxdale problem and you have an updated and enforceable termination provision and enforceable termination related provisions in your other documents like bonus plans and commission plans and even employee handbooks, then you should celebrate that, and you're kind of in the VIP room after that. Your termination is probably going to be pretty tidy because you have certainty that you've created at the beginning of the relationship. So congratulations, and this is going to make your life a lot easier. You can use we have our termination letter A. We have A to D that we use and work off of and customize for our clients. Our termination letter A is lovely to provide to employers because it's basically an information letter that says you know, your employment terminates this date, and here are all the things that apply. They don't have to sign it back. No release is required. It's straightforward and usually quite simple, and the termination meeting is quite simple as well. So that's the goal here. That's what we're trying to get employers to that point, so that it can make their lives easier on this difficult topic. So what if you have a potential Waxel problem? What if there's a potential issue with a termination clause or a termination related clause? Tiffany referred to employee side counsel going through the clauses with a fine tooth comb. That's what we're seeing regularly, and it's a bit of a cat and mouse game where employers try to clean up their clause and employees are constantly, you know, picking out phrases that where courts have said it's a potential issue, or they think courts might say there's a potential issue with a termination clause. So there's a constant cat and mouse game with employee and employer counsel. And so what we often do is when we look at a clause, I will rate it. I'll say this is a 7 out of 10 or an 8 out of 10 or a 9 out of 10 and decide how likely it is to be a problem. And if it's a really terrible outdated clause, you might adjust your severance package accordingly. You might not. You might just go based on the language and wait and see if the employee takes issue with it. But it's important to identify whether there is a potential issue so that you can, for mapping out costs and advising your leadership team on what might come down the pipe after the termination. It's important to understand what might be coming at you. And that's part of what we do when we help with strategic advice on severance packages. We will say, this is what we recommend in this situation, but this is what you may hear back from employee side counsel, and we can deal with it at the time if the issue is raised. So if there is a potential issue, as I said, you might change your severance package and tweak it slightly. You might offer certain things on a gratuitous or good faith basis in order for quicker closure. Whether or not the person's entitled to that or not, it might just be that, frankly, termination is for business reasons. They were a great employee. You want to reward them. Nobody wants to see them go, but it's a business necessity. So you might decide to offer more. And whenever an employer offers more, we encourage them to get a signed release just for closure. It's just part of the tidiness of these without cause terminations. In exchange for a signed release, you do have to give something above employment standards. Otherwise, the release won't be enforceable. And that's known as consideration. That's the legal term for something of value to an employee. Courts don't scrutinize what that additional consideration needs to be, and so it can vary. It's typically an increased severance package, whether it's another week or some other payment on top of what's owed either under statute or by contract. Understanding the potential employee response is important so that you can make the best business decision at termination around what the severance package is going to be. So when an employer comes to us and gives us that initial employer bio information and we have a meeting, I will often ask, what is the employee likely to dispute this? What's their view? What are their personal circumstances? And try to get a sense of what's going to lead to a quick resolution. And sometimes a conversation about the specific circumstances can really help get a quick resolution.
Thanks, Marnie. Let's talk about now tidy without cause terminations. So as you likely know, here in Ontario, we have two types of termination. That's pretty common across Canada. There is both with cause and without cause terminations. The focus of our presentation is really on without cause terminations. We certainly advise regularly on cause terminations, and we will touch briefly on, cause terminations later in the presentation. But quite frankly, we could do an entire presentation all on its own, just about, with cause terminations. Ultimately, we're focusing on without cause terminations because they truthfully are far more common. You're much more likely to encounter them in your experience. So really, an employer can terminate at any time, save and except for legal reasons, but you are required to provide notice of termination of pay or pay in lieu of notice. So just briefly, some of those illegal reasons are going to be things like terminating for a discriminatory reason or terminating due to reprisal. So of course, you want to avoid those reasons, but otherwise, so long as the reasoning is legal, you can terminate at any time, You just have to be willing to, provide notice or provide pay in lieu of notice. So one thing that's often overlooked that we'll touch upon again later in the presentation is that this notice can actually be working notice, or it can be pay in lieu of the working notice. Working notice can really work in situations where the working relationship is essentially untarnished. So this would be in situations, for example, where you're merely just winding up a portion of your business and you're not going to need those employees anymore. Very often it would be a fine idea to structure this as working notice, where you want to be careful as if there's been some sort of breakdown in your relationship and you can't necessarily trust the person to continue working in a loyal and confidential manner, in an appropriate manner through the working notice. So generally, in terminations, there's three essential buckets. There's the bare minimum of what the employee is entitled to. That's always outlined in the applicable employment standards legislation, which of course in Ontario is the Employment Standards Act. So again, this is just the bare minimum of what they're entitled to. There's no contracting out of the ESA or applicable ESL legislation where you absolutely have to provide these bare minimums, except in very situational circumstances that are typically for cause terminations. Then we're looking at the next bucket of entitlement, which is really, what does the contract say? If you have a contract, what does it say, and what does it say about their entitlements upon termination? And finally, the third bucket that we're sort of looking at are the potential common law entitlements, which are, for your knowledge, far more generous than what's outlined typically in a contract and far more generous than what's in the employment standards legislation. So those are the three sort of buckets that we're concerned with upon a termination. The analysis on termination always comes down to a question of how many weeks of notice the employee is entitled to. This is typically a pretty complex analysis depending on what your employee has received and enjoyed during their employment. Essentially, what we're always trying to determine is if the employees were sitting in their chair, working through their notice period, what would they be getting? What would they be receiving from you? So you can expect that upon termination, the employee is going to be focused on what they're missing. So for example, if they've enjoyed a few little perks throughout the course of their employment and they would have continued to enjoy those perks had this been working notice, you can expect that their focus is going to be probably pretty squarely focused on getting those little perks. So you need to be thinking about things like benefits, bonuses, or allowances, and thinking about what that budget's really going to look like heading into your termination. Just a brief note on sort of the confusing language that sometimes surrounds termination that we do a lot of, introductory sort of advising on, just giving information on to help clarify. It's sort of confusing here in Ontario because we often refer to the payments that are received upon termination just generally as a severance package. However, in Ontario, we have a particular sort of termination payment under our Employment Standards Act, which we generally refer to as ESA severance. And severance is only applied under very particular circumstances. It's typically employees who have been with the company for more than 5 years and your company has a payroll of $2.5 million or more. So just to help clarify, it can get a bit confusing at times that we just generally refer to these payments as severance payments, but there is a specific ESA severance payment requirement for some employees here in Ontario, so just keep an eye on that.
And I just wanted to add, sorry.
Go ahead, Marnie, sorry.
Yeah, Tiffany, I just wanted to add one comment about working notice because it's sometimes a forgotten tool for employers. It can be a disaster in certain circumstances, but one other thing you can do in a working notice scenario is offer a retention bonus or a stay bonus if to incent the employee to really, if they're a key employee or they have legacy knowledge that's important, if it is a wind up, even if it's not a wind up and it works for the employee to be looking for work while they're still actively employed, that's where it can be a win-win scenario. And it can really reduce termination costs because the employer is getting the benefit of the employee's active employment. Now, most employees prefer to be paid to do nothing, but not always. And that's where a retention bonus, or sometimes called a stay bonus, can be helpful. And, if you give them appropriate time off to look for work and help them in any way you can, a working notice scenario can actually work quite well. Okay, sorry, this is my slide. Without cause termination packages, I've already talked about how you're going to assess termination-related provisions and decide are they enforceable or not. If they're not, you're going to think about what does that tweak what we're going to offer. Once you've decided what number of weeks or months you're going to offer for a notice period, if you don't have that that airtight ESA clause, you're in common law notice land. So what's the number of weeks or months going to be? Doesn't matter how you set it out. And then you're going to make sure you understand the ESA requirements. I do find sometimes there isn't a clear understanding of ESA termination pay and ESA severance pay if it applies, if the employee is 5 or more years of service, and the payroll is 2.5 million or more globally, not just in Ontario, then you need to have that on your list and understand what the employee's entitlements are. And there's a great severance calculator online the Ministry of Labour has available to understand what the ESA requirements are. If the employer offers benefits, you're going to continue those at least through the ESA notice period, and then calendar important dates when those benefits are supposed to end according to whatever severance package you put together. And be very mindful if the employee has health issues that you're aware of, or that even that if you're not aware of health issues, employees, if they have a health issue arise during the notice period, it could be problematic for the employer if they discontinue benefits prematurely. So before ending benefit continuation, it's worth checking with your counsel if you're in the middle of negotiating a severance package, rather than just instructing the insurer to cut them off. Be aware of where you're at in the process, and it's not that expensive to continue benefits coverage and can mean a lot to an employee. So just be cautious of when you're ending benefits, and especially where there may be health issues that pre-existed the termination or may have arisen in the notice period. You're going to want to pay attention to ROE and other payment timelines, statutory payment timelines, and make sure you comply with those, because if you don't, it just gives employee counsel something to add to their demand letter about Employment Standards Act breach or statutory breach. So those are all ways to keep your termination tidy and pretty easy to comply with. I talked about working notice already because I tacked it on to Tiffany's intro of that concept. Another helpful tool, sometimes, not always, is adding a mitigation clawback to your notice period in your severance package. And how that works is if you offer somebody a 6-month notice period, for example, in order to incent them to reemploy more quickly, you can say once you reemploy, say at the 3-month mark, you can keep you will receive 50% of what's remaining in your severance package. So if they reemploy at the 3-month mark of a 6-month package, 3 months are left, and they get to keep 1.5 months, and that will be a period where they're being paid by their new employer, and by you, the employer, and then the employer saves the final month and a half of pay. So I see that as a win-win scenario that can, in the right circumstances, incent an employee to go out and look for work and have that period where they're paid by 2 employers. It doesn't always work, and that's where you're going to look at the situation and see if this would actually lead to faster reemployment. If your employee is, indicated that they're intending to retire, don't ask about retirement. But if they offer that up, you don't want to get into a problem of discriminatory conversation. But if they offer that up and they've indicated they just want to spend time with their family or grandkids or whatever it is, mitigation clawback's not going to probably be helpful. So don't confuse things by inserting that into the termination letter. But if you've got someone who's got a great resume and is likely to land, and the job market is good in their sector, then this can be a very useful tool for quick reemployment. And then the employer's costs or damages, if it's going down a litigation route, are crystallized at the point that they reemploy. So I've said before, I don't like the word clawback because it makes it sound like they're losing something, and I don't call them a clawback in a termination letter, but you'll often see them where it's a 50% reduction when they reemploy. It's not a negative thing. It can be a win-win, and I've used it to both employee-employer advantages recently. So keep that in mind. Then you're going to want to understand bonuses, commissions, and anything else that is part of the employee's compensation package. So Tiffany already talked about what would they get if they were in their chair for the full notice period, or you can think of what are they going to come back and say, wait, you forgot to pay me this. Consider that and have it in your list. You may decide not to pay it on termination. You might say they didn't earn a bonus and here's why, and we've looked at the bonus language and none are being paid, and they didn't meet the the terms of the bonus plan, the performance measures, and so on, or the commissions have been paid out or they're not owing. Just understand whether you're paying it or not, and formulate your termination letter or severance package accordingly. And just have a good sense of every item that they may come back and ask about, because it makes it cleaner and reduces the number of questions after you've had the termination meeting and provided the termination letter. So when you're preparing the termination letter and deciding what the severance package is going to be, you're going to have already reviewed your the employment contract. You're going to do that right at the outset to figure out what you're looking at in terms of costs. But you're going to align the termination letter with what's in the contract or offer letter, and you almost use that as a checklist. Go through the contract and see, okay, what are we dealing with here? Pay attention to certain obligations that the employer may have nailed down at the time of hiring, because some of them apply to post-employment, and they're important, especially with certain employees who have the potential to cause harm post-employment. So I'm talking about restrictive covenants and non-solicitation clauses. If there are valid non-compete clauses in the contract, you may want to insert that, or we encourage employers typically to insert that in the letter, because some employees forget about it, or they think the employer doesn't care about them, and they go ahead and breach those terms. So it's a way to get ahead of it and level set and have both parties understand what's important to the employer on exit. And I already sort of described the termination letter as use the contract as a bit type of checklist. Go through, see what you need to deal with, and then you can also draft the termination letter as a format of a list that can be a quick reference for both the employee and the employer. So HR or payroll, whoever is using that and administering the payments and mindful of timelines, we like to draft our termination letters in a really clear way, numbered paragraphs, so that if you end up negotiating terms that change, it's clear, and whoever's at the tail end of the process dealing with settlement understands what needs to be paid and when. And the employee, like some of the ESA concepts and common law concepts are hard to understand, and we separate them and try to make it very clear. And where possible, we actually include exact amounts in bold and payment timelines if there's time to do that. So the employee can properly assess the package, and it might save them needing to go and incur the cost of a legal advice to review their severance package if they really have a clear letter and understand what they're getting, which is, I think an important goal. If you can save them having to incur fees and go get advice and be very clear about what they're getting, and they can make that educated assessment on their own, that's helpful. I've already talked about calendaring important dates in terms of ESA obligations and benefits continuation and payment of final settlement amounts if you negotiate an additional amount and it's payable within 31 days and so on. Just calendar that so you avoid having an upset employee coming back and a payment that's missed. So that's just, again, all part of a process that should be part of your checklist.
Thanks, Marnie. I'll just pause briefly before I move to this next slide, which is important. We have some good questions coming through, and just on this matter of the termination letter, I will mention briefly, I can see some people wondering about the level of detail required in a letter, and we'll touch on that a bit later in the presentation again. But what I would say generally is that for me, I find where you can provide specific numbers, where you can break down how things are going to work in terms of these are your ESA payments, here's what they look like, here's when you can expect to receive them. I find that helps set the tone for the termination, because in the cases where the termination letter itself is really unclear to an employee, I think you're just increasing the likelihood that they go out and seek legal advice and say, I don't even know what I'm really getting here and why I'm getting it. And that doesn't set a great tone for them, because I think they're perplexed, and I think they don't trust you at that point. And so for me, I would say from a tone perspective, be clear about what they're getting and when they're getting it. So if you have the opportunity, and this is something we regularly do, is, set out the amount of their notice amount. So if they're getting 1 week for the ESA requirements, say what that amount is going to look like, and say when they can expect to be paid for that, right? I think it just really helps set the tone. So let's talk briefly here about employees, which I'm willing to guess the majority of you listening in today have experience with, and those are what we would call challenging employees. So there are plenty of experiences, I'm sure we could all sit down and share them, in which you sort of know, okay, something's going wrong with this employee. It might be a performance issue, it might be misconduct, it might be serious, it might be less serious, right? And so what we're really focusing in on here is just an employee who's having some performance issues, and you're trying to sort out, what do I do with them? So I think you have to make an assessment as an employer, and you'll often know, I think, in terms of, can this employee essentially be rehabilitated? Is this something that we want to enter into? Is there a way to salvage this relationship? Of course, the costs of hiring and training are expensive. You don't necessarily want to outright fire someone. You're having some issues. Is it really worth working through? So I'll say a couple of things on this point. First of all, we do sometimes get employers who come in who say, there's all these performance concerns, their work just really isn't up to snuff, they're late all the time, I want to terminate them, and I want to do it with cause. Typically, we're going to say that's probably not a great idea. So with cause, terminations are really onerous to establish when it comes to, a court. And so for us, we often, I'm not saying always, but often advise maybe a without cause termination with a package is the better idea. Now, I recognize and acknowledge the fact that if you're already struggling with this employee and they're causing some disruption to productivity or to your workplace, you probably aren't going to hear my advice of pay them some money with, a smile. It's a tough pill to swallow for sure. And so I think you need to look at it in a couple of ways and really with a practical lens. So again, if the employee is, worth really working with, there's a relationship to be salvaged, maybe you walk the road of putting them on a performance improvement plan, having that kind of heart-to-heart discussion with them. We need to see some improvement with you. Maybe you consider disciplining them with a view to hoping their performance improves. Now, you also have to consider the employee where things are going wrong with them, performance concerns, that sort of thing, a lot of disruption to the workplace, you don't really see that this is going to improve, and you're thinking about terminating them, okay? You're welcome to spend the time that it's going to take to lead up to a with cause termination. However, what you have to recognize is that, number one, as I've said, cause is a hard threshold to meet in Ontario. It's pretty arduous to establish, quite frankly, especially in cases of poor performance. So if you're looking at this from the perspective of, okay, I'm about to spend 3 to 6 months potentially putting this progressive discipline process in place, which in and of itself is going to be time consuming and expensive, and you're also still dealing with an employee who's probably not as productive as you need them to be. They're causing you, productivity issues as you're picking up their slack. They're likely causing disruption to the workplace as your other employees are looking around and thinking, why is this person still getting away with this? And, your costs continue to increase as you continue to pay them and deal with all these productivity issues. So at that point, before you enter into this road of progressive discipline, it's time to step back, I would say in most cases, and consider, is this really worth it? Or at the end of this progressive discipline or performance improvement plan period, am I just going to be left with ultimately terminating this person anyways, likely on a without cause basis, and paying them out for their notice period in any event? So you really want to think cautiously and practically before walking this road. Start, as I say, with analysis of, can this be salvaged? Certainly not recommending you just outright terminate people every time a challenge arises, but making that assessment of, can this be salvaged? And if so, what does it look like? Or is this person truly just not a fit, and is it maybe time to let them go and walk the without cause road? Now, the last point I'll say on this is that I see commonly is employers who come in after 6 months of frustrations with their employee and say, well, in month 1 they did this, and in month 2 they did this, and in month 3 they did this. I cannot emphasize this enough. Do not keep a running list of your employees' issues and not address them at the time, or expect, that 6 months down the road we're going to start being able to discipline for things that happened 6 months ago. It's pretty hard to do that. And so I would say, don't wait too long before you reach out, speak with one of us or your existing lawyer and say, how can I address this? There are some situations, first of all, let me just say, that will meet the test for cause. That's totally possible. It's best to think of it big misconduct issues. So certainly don't ever write off the notion of a for-cause termination. Now, in some cases, even in cases, say, of misconduct, we will consider a sort of two-letter termination approach, where we will actually terminate for cause, but in a separate letter, we offer a package to avoid, the need for legal action. But this sort of approach needs to be carefully considered along with your employment law counsel. But it's something to keep in mind for future. But again, I would only recommend that, really in consultation with your employment law counsel. Okay, so let's talk about your legal obligations and some practical structuring for this termination. So Marnie sort of referenced this, and so have I. I like a really clear termination letter. I like them to know what their basic minimum entitlements are, and I like to put that up front so they know what they're getting. You're getting this no matter what in a without cause situation. Here's what it's going to look like. Here's when you can expect it to arrive, and here's all the things that it's going to include. So, for us, when we draft these, we're looking at, here's what the notice is, how much is that going to be, when can you expect it to arrive. By the way, your benefits are continuing through this period. You're getting all of your accrued and unused vacation. That's another requirement of the Employment Standards Act. And by the way, we're going to be issuing your record of employment within, 5 days of your last payment, whatever the legal obligations that are there and whatever you're going with. Okay, so that's sort of up front. If you're providing a package, then I like to put that in a separate section so that they understand that they're still getting their minimum entitlements no matter what. The second part of the letter addresses the fact that, hey, we're offering you this package in exchange for your signature on a full and final release. And you're doing that to just mitigate any risk of them, taking formal legal action. Might not be in every case that you're going to offer that package up front, but if you are thinking about it, I like it to be separated out so it's abundantly clear exactly how this termination is being structured. I would say before you enter into the termination meeting, it's really important to give some careful thought in terms of what you plan to say during this meeting. Different employers take different approaches. I certainly help some employers create more of a script, and certain employers just sort of bullet points about what they're going to talk about. I would never advise an employer to enter into a meeting and sort of look down at their script and read off of it. It feels very robotic and cold to an employee. Again, that's a tone thing, right? You don't want to set the tone that this is just a robotic, another meeting for you. You certainly don't want to be overly emotional, but you don't want to be reading from that script, but you want to know what you're going to say. Typically what we say is you don't need to say a lot. You can explain the elements of the termination letter. You certainly don't need to read the letter to them, but you can hit the highlights of sort of what the letter says. We typically say, don't get into the why. Unless there is a very clean legal and business reason for the termination, and it would be abundantly, very abundantly easy to explain, that's one thing. Otherwise, we typically say, avoid the why. One thing you certainly want to avoid is suggesting that there's reasons in a without cause termination, things like, oh, because you were always late, because your performance has been really bad over the last year. It's really not the time, and again, it can set a bad tone. And the other thing you really have to be cautious about in these meetings is you, as the employer, do have a duty of good faith in the manner in which you dismiss your employees. And so if you enter into the meeting and you are in any way inappropriate when it comes to the law, what can happen is you can end up attracting damages for your behavior through the termination process. So again, you want to keep it short, you want to keep it professional, say what you need to say, and avoid saying more, certainly making any reference to kind of their performance or, any of the reasons why they might be terminated in a without cause. Common question we get is, sorry, Marnie, go ahead.
Maybe you're about to say this, but I just wanted to jump in and say, this is a good reason for doing regular performance reviews and keeping objective notes in these performance review reports about the employee's performance and having meetings with them, because then this termination is less of a surprise and they're less likely to ask for a reason. So there's lots of business and performance management reasons to have these performance review meetings. It's not even performance management, actually. It just helps help them succeed in their role. But if it's come to the point of termination, again, this won't be a surprise or be less of a surprise to them in the meeting, and they're less likely to ask. And in terms of keeping notes, you want to keep your comments objective, and are they meeting their performance measures or not, and be cautious about the notes you keep, and avoid making comments about that could get into potentially alleged discrimination, those kinds of comments, especially if the person's dealing with a health issue and so on. You just want to be cautious about what you keep in your notes, because sometimes they are producible later on. Sometimes, so you want to assess them objectively and keep the performance review reports in a way that are detailed enough to be helpful to manage them, but also make it clear to them, hopefully, the reasons for exiting. And there's one other comment I wanted to make about the script on termination. If you're offering something to them that is more than what they're entitled to, make sure they understand that, because that will soften the landing, and they'll understand that the employer is making a decision to offer them more, and can help with that swift sign off too. So make sure that's clear, and we try to make that clear in our termination letters as well. So that was a point to add in the talking points. So we sometimes will help employers tweak their talking points, which are typically 2 to 3 bullet points, but make sure you highlight what you're doing that's above and beyond what they are contractually entitled to, or above and beyond what is their statutory entitlement. I think we've answered a question on what to say in a termination meeting that came in, so I'm going to check that one off the list too, because I'm monitoring questions that are coming in. Okay, back to you, Tiffany.
Thanks, Marnie. And so one common question we get in this post-COVID world is, are virtual meetings okay for terminations? What I would say is, if you're operating in a virtual workplace, certainly, yeah, you can have the termination meeting virtually. If you typically operate in person, I would be cautious of doing that. Again, think thoughtfully in terms of, how is the employee going to take this, and how can we set the tone on the right foot from the get-go? So there's a few other points that we just want to raise in terms of, being prepared and handling this smoothly. And part of that is really facilitating reemployment. So as Marnie has referred to, the employee does have an obligation to attempt to mitigate their damages by finding new work through, large chunks of the notice period. And so how does that really work, and what can you do to help with that? Sometimes employers will feel like, well, why should I have to help out with that? That's their job. And what we always say is, well, ultimately, if you can help them and it helps them land a new job, it helps us understand at what point, we know when the damage is sort of crystallized to some extent at that point. Doesn't mean the notice period is over and you might not have continuing obligations, but really, reemployment is a win-win for everyone in this scenario. And so ultimately, we would recommend in most cases that you consider things like giving them a reference letter. It's a really tough sell, I will say, on the other side of things, to an employee when what you're issuing is what I refer to as a tombstone letter. So when it's their name and the dates of their employment, pretty tough sell for them to accept that, because really what they need to go out and do is find new work, and that's not really going to help them get there in most likelihood. So think about those things. If you have the budget for it, think about outplacement services. Can I set this person up with somebody who's going to help them find a job? The other thing that we often do, or often advise our employers to do, is start monitoring the job market. If you know that there is a great deal of opportunities out there, start saving them. Save the job posting. If it's comparable employment in terms of its nature, and if it has a salary, that's even better, and that it's pretty comparable to what they're leaving, hold on to those job postings. In some cases, it's case dependent, but in some cases, we'll actually send those to the employee, bringing them to their attention. So those are all good things to be doing. The other thing that you really want to be doing, just in terms of the overall negotiation process and working with your lawyer, and Marnie referred to this earlier, is just really understanding who you're dealing with, right? And that's important for the entire termination process. So, understanding who they are. Is there a particular family situation at play? Are they the primary income earner? Are they going to need to reemploy quickly? That might change the way you decide to negotiate. It might mean you do introduce a mitigation provision, right? And so understanding those things and who the employee is, what's likely to be important to them, is important psychology does factor into this, and so it's something to keep an eye on. Over to you, Marnie.
Okay, thank you. We're getting a ton of questions. I'm trying to weave them into the presentation, and I'm mindful of time here, so hopefully we can get to as many as possible. This slide has a number of concepts we've already talked about, so I'm just going to move through this fairly quickly. Some of the things to watch for where you get an otherwise tidy termination that becomes a little more untidy is where you fail to account for the ESA minimums. So there was one of the questions about severance pay and ESA severance pay and regular severance pay. So that's where Tiffany was talking about how the terminology can be confusing. And there are great resources on the Ministry of Labor website that talk about the difference between ESA severance pay and ESA termination pay, and then common law notice. And so there are great resources to tune up on those concepts. And understand why they're used interchangeably and why there's confusion. And this is why we're really clear in termination letters to set out what we're talking about when we apply the amounts. Extending only base salary without considering the other entitlements. We've talked about that already. So you're going to look at all the entitlements, make sure they're included. There was a question that came in saying, do we have to itemize the bonus and all the amounts? It's recommended because you're going to reduce the questions back and forth. You don't want to put a lump sum amount and then have to meet out what applies to what. So the more detailed you can be, the better, but it's not a statutory requirement to itemize at that level. You do have to say what the termination pay is and what the severance pay would be. But I think if you've got commissions and bonus and everything else, line it up for them so they can, and even vacation pay amounts, they need to know whether it's on a pay stub or in the termination letter, they need to know what the vacation pay number is. So just be as detailed as possible if you can. I will say we do get a lot of Friday afternoon questions about we're about to terminate, to which we often say maybe Monday is better, because doing it right before a weekend is never really advisable, because the person just ruminates and thinks about getting counsel and gets more entrenched in position. So, but what we often have is a quick rush termination, and so you don't need all the numbers in a termination letter. You can provide the information later to the employee if the termination has to happen quickly. So it's not essential or a legislative requirement, this level of detail. It's just part of the tidy process. One thing, a pitfall I would say is when you're negotiating a settlement is failing to confirm that whether the employee has an employment offer or a pending offer when you're negotiating, because the last thing an employer wants is to agree to a large sum of money only to find out the next day that they've landed another job and they didn't have a legal obligation to pay them that amount. So it's worth in the negotiation process keeping your ear to ground, hearing if you have that information or some intel on what the employee is up to, so that so the severance package is reasonable at law. An employer is not obligated to pay someone beyond when they land back on their feet with a new employer. So you want to ask those questions and draft them into your settlement documents. And obviously not having a termination letter or an unclear letter is not advisable, and we've talked a ton about that. And I also talked about flagging items that are being offered in exchange for a release, because that will help with the softer landing and is more likely to lead to a quicker sign-off. Okay.
Thanks, Marnie. And Marnie just sort of referenced this in a comment that she made. There's rarely going to be times that feel like the right time to terminate. It's not the most exciting part of your job. It's probably the most uncomfortable part of your job as an employer. But there are times that are really bad, and times that can quickly lead down the rabbit hole of, is this an illegal termination? And so the decision on timing can have a big strategic impact on really what comes next, what the negotiation process looks like. So the common things I see here are things like immediately before the holidays, during someone's vacation. Certainly the Friday afternoon termination is not a great idea. Also, if you know your employee is going through a particularly bad time, if you can afford to give yourself some leeway, I think it will save you in the end, because ultimately, if they're already in an emotional state or they're on vacation and this feels especially callous, you can kind of expect that to impact the tone of the negotiations on a go forward. Legally, when it comes to things like ESA protected leaves, human rights issues. A big one we see consistently is termination, like immediately following a sick leave or during a sick leave. Maternity leaves are something we, advise on quite a bit in terms of the timing of the termination there. These things are really big considerations. And ultimately, all of these considerations just amps up the emotion, and it can play into accusations of bad faith. We're increasingly seeing complaints based on, is this a reprisal? They're on the rise, okay? And so if you give the employee the opportunity to sort of complain about the timing, the likelihood is they will. Ultimately, be thoughtful, be considerate, think about, how is the employee going to take this? The other thing you really want to consider is, are you on the cliff of something that's big and important to the employee? And if so, things like bonuses, you can expect them to complain about those sort of things. So keep all that in mind.
Okay, I'm going to get to the demand letter in a second, but I'm going to answer one quick question that I think is fairly straightforward. Someone asked, are outplacement services, do they count as consideration, especially if it wasn't a prior practice to provide outplacement? So the short answer is yes, any additional item, whether it's pay or outplacement services or any other perk that is beyond what they're entitled to, that would be valid consideration in exchange for the release. I typically don't advise that outplacement services or a reference letter should be conditional upon an employee signing, because it's in everyone's interest for the employee to reemploy quickly. I recognize that outplacement services can be expensive and it's a big ticket item. And so employers often do want to make that conditional. We're making the spend and we want you to sign a release for finality if we're offering it. But in lots of cases, it's worth the spend to get them to reemploy quickly, because it will reduce, it could very well reduce the severance package owed to them. But I think what you're looking for is what counts as consideration. Anything additional would be valid consideration. Your release would be enforceable. A related question is, to confirm, we're not legally required to have a terminated employee sign off on their letter, right? They're asking for confirmation, and what needs to happen for that to be acceptable. So I would say if it's a straight termination and they're getting ESA only, it's an information letter you're giving to them, you don't need sign off. In every case where an employer is offering something additional, I always recommend getting a release in exchange for that, because then you have closure and finality. And this question said, if you don't get a release, then we could end up in a he said, she said scenario. If you don't get a sign off from the employee. Well, when you're getting a sign off, there's the release that says everything's over, and then there is no he said, she said. So you're not legally required to get a sign back, but it provides the closure to the employer, and there's no conversation about he said, she said after that. So there's a real, the component of closure makes it all worthwhile if an employer wants to pay more in exchange for that release. Jumping into the demand letter, and we're wrapping up shortly here. First thing I say, so the demand letter is typically from employee side counsel. Sometimes it is from the employee saying, this is what I want in order to exchange, in exchange for signing the release. Sometimes they'll make the proposal themselves. Sometimes they're writing it with the help of legal counsel, and sometimes it comes from legal counsel. So the first thing I would say, especially if it comes from legal counsel with all kinds of allegations that might be surprising to you and or your leadership team, take a deep breath. The tone and content of demand letters can often unnecessarily escalate matters. Not everything in a demand letter is going to be accurate, and it might be exaggerated with a view to trying to get a settlement. So that's never a pleasant letter to receive, but I will say often it's allegations are made in order to get to a tax favorable settlement as well. And so I always say there's usually a panic when I get letters that are inflammatory, and that is the first thing I say is, let's just break this down. Give me your response to what they're alleging here. And I usually, or not usually, but quite often I get on the phone with opposing counsel, which the employment law bar is quite small in Ontario and Canada. We have a without prejudice conversation. You can get to the chase of what the letter really means. And so there's a lot of window dressing in demand letters sometimes. So take that deep breath before your entire day gets derailed, and talk to your employment law counsel and figure out, okay, what are they really seeking here? And the first step would be to send a placeholder email saying, we're reviewing this and we'll get back to you, especially if there's a deadline in the letters. This is so that you don't miss the deadline and have a statement of claim land in your inbox and get time to actually prepare a thoughtful response to the demand letter. And then you're going to work with your counsel, most like that. This is one scenario where I say it is well worth the legal spend to work with counsel on decoding the demand letter and figuring out what a settlement path might be, or maybe it is that this is a matter where it needs to be litigated. But I think this is where you are working with your counsel typically on these, and that's well worth the legal spend. So it's often, if it's a narrow notice period dispute, you're going to review your initial notice period analysis that you did before you prepared the termination letter. And then you're going to have a strategic legal and business analysis conversation with counsel, and you're going to decide, are we going to increase what we offered on termination, or are we going to hold firm? And a lot of that's going to depend on cash flow, whether you want to pay what's sometimes called a nuisance payment. I don't love that term, but it's just a payment, no admission of liability. Let's pay this person this amount or a portion of what they're seeking, because everybody's time is better spent focusing on the business and their day-to-day duties at work. So that's the business analysis that often happens when it's only a notice period case, really. Sometimes there are these other allegations I've referenced before, where they're bad faith manner of dismissal, or they're alleging that they've been terminated by way of a reprisal for some complaint they may have made, or they're making allegations of discrimination and breaches of human rights legislation. And again, those are things you'd review with your counsel. Is there merit to this? And your counsel will help you do a risk assessment and figure out how strong your case is, and therefore what might be worth paying. Here's a range, or maybe it's we pay nothing and let the statement of claim come. So there are a lot of paths that this could go. But it all starts with your initial assessment of the notice period. Keep all those notes, keep everything you did, what you prepared for counsel in terms of the employee bio, and that will really help if and when you get a demand letter in terms of how you're going to respond to that. So this is, in addition to the termination meeting, which is not fun, a close second is probably getting a nasty demand letter and just get a plan in place and try to resolve it with your counsel in a practical way without getting too derailed. All right, so we are 3 minutes over. These are more best practices. We've touched on some of them. Planning ahead is key. You're going to look at things like working notice. You're going to pull out your written performance assessments to support the termination decision. Those are especially important because somebody might say, I was fired for this reason, for reprisal, or the sick leave I took. So those written performance assessments I've already talked about, and how it's important to objectively document performance and cautiously, without too much editorializing that could get into trouble, get an employer into trouble down the road in the event of litigation and having to produce those documents if they are not privileged. You're going to use your termination checklists with lots of the items that we've talked about today. You're going to have your script or talking points, and you're going to tailor them according to the person so that you can make as soft a landing as possible for that person. Consider whether there are no cost items that the employer can add to the termination package or the exit to help that person land on their feet and reemploy quickly. And also, if for no other reason then it's just a nice, humane thing to do, it's good for the employer when people leave and say, I was treated with dignity on exit. So think about what would be helpful to them, especially the no-cost items. Sometimes employers get positional and you don't want to be helpful, and there's just no reason for it in many of those cases. Obviously, avoid actions that could be viewed as bad faith in the manner of dismissal, because those can lead to expensive damages, or just delaying a settlement process, because we get into talking about facts and allegations and did this happen or did that not happen, and it's a waste of time and money in many cases. And as a final parting comment, in case you haven't gathered by this point, checking your contracts and all plan documents and related documents for up to date, whether the termination related provisions are up to date, is really important, because you can avoid many of these questions and issues if your clauses are up to date and you're in the VIP room with your tidy termination clause, and everybody knows what they're getting, and it's a simple termination meeting and everyone's off on their way. So I'll hand over to Tiffany to wrap things up with takeaways, and I'll see what other questions we may be able to answer quickly here.
Marnie, yeah, so again, seeing as how we are over time, we'll sort of just give you a few highlights here. As Marnie says, the contract matters, the terms matter, the documents matter. Collect those and be prepared to discuss them with your legal counsel. There are cases where without cause route is just the tidier option, and keep that in mind. Ultimately, I think the big takeaway here is consider the decision carefully, be thoughtful in it, understand your employee's entitlements and the risks involved in the termination, and seek that strategic legal advice. Ultimately, it can be efficient and can save you a ton of money in the end, so it's a really good thing to consider. Marnie, I'm not sure if there's any sort of quick questions we can answer, or if we're going to end it there for today.
I think we have a slew of questions. This is always a hot topic for employers. I think we're going to have to call it. Of course, feel free to reach out to us, and it really is satisfying when we can help employers with tidy terminations, and feel free to reach out with your specific questions. And we're here to help. But I think we have to call it a day here because we've got too many questions to get to today. Thank you everyone for joining us. We had a great attendance list today, and we hope it was helpful to you.